Hello, and welcome to WITA's Exchange podcast. We're recording this week's episode on Thursday, November 6th at 11:30 a.m. U.S. Eastern Time. So depending on when you download and listen, the trade issues we're discussing today may have changed. Yesterday was the World Series for trade nerds, as the United States Supreme Court held a lengthy hearing on the legality and constitutionality of the tariffs that President Trump imposed under IEEPA, the International Emergency Economic Powers Act, that the president cited when imposing fentanyl tariffs on Canada, Mexico, and China in February, and more consequentially for the whole world with his April 2nd Liberation Day tariffs. Today, we're bringing back our crack team of legal experts to break down what they heard from the justices and share their views on the arguments made by the plaintiffs and the government. Welcome back to the Exchange podcast to Kathleen Claussen, professor of law at Georgetown University Law Center and a former associate general counsel at the Office of the U.S. Trade Representative. Our discussion leader today, Michael Smart, managing director at Rock Creek Global Advisors and a former director for international trade and investment at the National Security Council, and a former counsel on the Democratic staff of the U.S. Senate Committee on Finance. And joining us in a few minutes will be Marty Lederman, professor for practice at Georgetown Law and a former deputy assistant attorney general at the U.S. Department of Justice. Mike?
Thank you, Ken, and thank you, Kathleen, for joining Fridays at the Exchange. Before we dive into the many issues that were discussed by the justices during the hearing yesterday, let's first get your kind of high-level takeaway, which I'm sure folks really are anxious to hear. What did you glean from the questions and the discussion about where the various justices are coming from? What are their areas of interest? What are their leanings for or against the government and the plaintiffs in this case?
Sure. Well, thanks so much, Mike, and thanks to Ken and the WITA team for bringing the gang back together again to have this discussion now. We are, of course, reading tea leaves, and so I think that should be said up front that we're, just trying to get a sense of where the justices are, as you said, Mike. But who knows? Who knows? I think there's a majority view out there. There's definitely a majority view out there that the government will lose. There is a minority view that the government may still win. After all, a lot of oral argument, right, is the justices in conversation with each other, trying to get a sense of where each stands. But I want to start, Mike, with my bottom line at risk of sounding like a broken record. We said this last time we were together, and I've been saying this since the spring, that from a big picture trade perspective, this doesn't matter. I hate to say that because, there's so much emphasis on it, but there's still lots of tariff authorities to be used. I hope we'll get into that. But all the hype about this being a massive case, the stakes are, I think, lower than the press would suggest. Okay, but having said that, it seemed that the court was more inclined to find the tariffs unlawful than maybe I originally expected, although my view has somewhat changed over time. I think that came down to, at least in part, the framing. Is this a case about foreign affairs, or is this a case about tax? And the leaning among the nine seemed to be toward tax. The government didn't do itself any favors by leading with this distinction between a revenue tariff, the Solicitor General said, and a regulatory tariff. This distinction was one that he came back to multiple times. It really seemed like a losing approach, and the liberal justices grabbed onto that from the beginning. That was, if you only listened to the first hour, you thought, gosh, this is going very poorly for the Trump administration. This distinction isn't really working. Now, in the second hour, when the plaintiffs had the opportunity to engage with the court, the justices raised a number of hypotheticals that suggested that they were concerned about line drawing. They wanted to seemingly test the plaintiff's theory about whether tariffs could never be allowed. Now, we've said before that if the court does leave any opening, even if small, for the president to use IEEPA to impose tariffs, it shouldn't be too hard for him to pivot and work his way into that opening. But, last time we got together, you remember Marty said that the court would have these other scenarios in mind. And they did. He called it, right? That was, we were discussing last time that I had made the point that what if we didn't have the worldwide tariffs? What if we just had these so-called secondary tariffs where the president just said we would put tariffs on products from countries that were receiving Russian oil, right? And I said, if that were the case, we probably wouldn't have any cases at all, right? Nobody would challenge that because you think Russia's bad, this is a reasonable way to use the statute. And so that came up, right, this sort of broader question of when IEEPA might ever be possible, climate change, et cetera. And so that's something I think to continue to watch. I thought the plaintiffs really struggled with that line drawing. Neil Catchall didn't really give a great answer, in my opinion. There was an example of what if the tariffs were imposed but never collected, right? There was a suggestion that this revenue idea wasn't necessarily a slam dunk, but nevertheless, I do think that, again, the point about two tariffs, one that may try to change behavior, I think that's what the SG was going for, regulatory tariffs that try to change behavior or create a deterrent effect, and one that tries, the purpose of which is to make money. It was just really hard to accept. If I were the administration, I might wish that I had gone a little bit more with the plain text. I think we said before, if we took a survey on the street, 9 out of 10 people would say regulate importation, the language of IEEPA, probably includes putting on a tariff, right, just in the abstract. Just like 9 out of 10 people would probably say that these two pieces of cutlery that I'm holding up, I know, Ken, it's a podcast, but I brought props. And so for those who may watch this in the YouTube version, I brought 2 knives. I'm holding up a butter knife, and I'm holding up a sharper knife that's designed for cutting meat, right? These are both cutting implements, and they both could be used for either purpose. I can use my steak knife to do butter, and I could attempt to use my butter knife to do steak, right? And so I think the fact that we put butter in front of one of them and we put meat in front of the other one doesn't mean that they couldn't both be used in either direction. They're still knives, right? I think, and this is the last thing I'll say, and then turn the floor back over to you, Mike, but I think what the government was going for was something more like what we see in international criminal law, that the law is on the books, but we hope never to use it. And this is what they say in international criminal law about genocide and the International Criminal Court in The Hague. Right? The fact that you can be hauled into court in The Hague for committing genocide, we hope will serve as a deterrent so that people will never commit genocide again. Doesn't really work here, right? For maybe 3 reasons. One, this isn't a criminal context. It reflects perhaps a misunderstanding of economic and business choices. It's something you can't happen overnight, right? Today I'm not going to do genocide. Tomorrow, tomorrow I won't do genocide anymore. Well, for a factory where you're importing auto parts, you can't just flip that switch, right? That's the first. The second is that we know this administration talks frequently about the revenue piece, and so to now come in and say this is not about revenue seemed a little difficult. And lastly, it really harkens back to the deal with legal issue in this case. Now, this is an issue that didn't come up too much yesterday. It's not really before the court in the way this has been teed up at the Supreme Court, but there's a question as to whether the tariff is an appropriate tool to deal with the language of the statute, these emergencies that the president has identified. And so, again, is this the way to deal with these issues? It doesn't really, again, it doesn't really work here. So that's it. I do think that the SG, the Solicitor General, and this is something maybe Marty can speak to more when he joins us. I think they got caught up in the sort of the government's incredibly broad position. This was targeted by Justice Gorsuch. That there are really no checks here on the president's massive power. But that's my bottom line, Mike. I think yeah.
That's terrific. So let me ask you about what you said. So if I understand you correctly, what you're saying is that by throwing out these various hypotheticals about other situations where tariffs could be used as leverage. I mean, it was Justice Thomas who talked about China holding hostages, or Justice Kavanaugh talking about Indian purchases of Russian oil, or the war in Ukraine. You're saying that leads you to believe that it's not so likely that there are 5 votes to say that IEEPA may never be used under any circumstance to impose tariffs. Did I understand correctly?
I'm not the best at counting votes here, and I will leave that to Marty, who's the expert, if he wishes to do so. He and I have talked about how they might slice and dice this, and we talked about this, even before the argument, if that were possible. But all it suggested to me, and this is probably about as far as I'd go with it, is that the justices, at least some of them, really wanted to test the plaintiff's theory and to ask them about those hypos. Is this a world in which you could never use this, the 1% tariff they mentioned in this circumstance? And I think probably the plaintiff's lawyer could have answered that better. As I said, there probably was a way he could have pivoted back to his revenue argument, and that would have been stronger for him. But I imagine that's something that the justices may wrestle with, and it really gets to the heart of, we still don't know what theory will be the basis for the decision. So even if we accept the headlines in the press that the government's going to lose, I think a lot remains on the table. And this is a good place for Marty to, I think, come in as to whether it's going to be through the plain text reading, whether it's going to be through some other aspect of the many theories, that were on the table.
Terrific. Marty, thank you for joining us. Before you get to the textual discussion, I would love to get sort of your top line takeaway. We've seen a bunch of the commentary since the argument ended yesterday that it wasn't a great day for the government. There were more skeptical questioning from at least some of the conservatives than folks had expected. Give me your bottom line, and then we'll kind of jump into some of the different issues that were discussed during the course of the hearing.
Sure. Sorry I'm late. I was with students at the end of class. I don't know how much you've covered, Kathleen, on this.
Decided the whole case, Marty. No.
No, I think it's hard to tell what the result will be. I think it is likely that there seems to be at least 5 justices, certainly 4, and probably at least 5, who are inclined to want to hold that IEEPA does not authorize the reciprocal tariffs or this kind of blunderbuss system of tariff, of changing every other week tariffs against every nation on earth by the president, and put some limits on the president's use of IEEPA for tariff authority. And the problem, of course, is that the easiest way to do that is simply to have a holding that says that IEEPA doesn't authorize the imposition of tariffs, full stop. But there's certainly worry among some of the justices, even those who I think believe that Trump is abusing this statutory authority or is acting beyond what any reasonable Congress would have wanted. I think they're worried about the hypotheticals in which there might be a genuine, and they finally sort of surfaced these in the last 20 minutes of the argument, when the Oregon SG was up there, where there's an actual foreign affairs-based problem in which the president might be able to use tariffs rather than some of the more extreme tools that IEEPA certainly gives him, right? Complete prohibitions, licensing, quarantine, quotas, all of those, right? The case starts from the proposition that everyone accepts is that IEEPA does give the president more powerful, more unbounded, more categorical authorities than the tariffing power. So why not the tariffing? Why doesn't the greater include the lesser? Or more to the point, and I think the justices were finally asking this the right way at the end, if you were Congress, why would Congress not have wanted to give the president this authority as well? Now, I think there are good responses to that both the Oregon SG and Neil Cottrell began to offer, that have to do somewhat with the history of skepticism in this country going back to the founding about entrusting the president with a taxing power because of the possibility of abuse. But regardless of what the reasons are, I think I think there's a good deal of doubt among the justices, as there ought to be, that Congress, for whatever reasons, has actually wanted to give the president the sort of unbounded taxing power that the president is exercising here. That seems deeply counterintuitive in light of all of the, highly reticulated, extensive body of statutes that Congress has enacted over the years that deal with tariffs, some of which are very broad delegations, others of which are more cabined. Some, they're conditioned in certain ways. This has been a place where Congress has been very hands-on, unlike all of these other powers, or many of these other powers that are implied from IEEPA that are not very heavily regulated or specified in the rest of the US code. Tariffs are. And so why would Congress have wanted to give the president such an unqualified, unbounded tariff power? That seems deeply counterintuitive. But on the other hand, why would Congress want to preclude the possibility of the use of tariffs when that is the most tailored tool to an actual discrete problem that exists with respect to foreign affairs or national security? And I think if there were an easy way to get to that distinction, which might track a distinction between the fentanyl tariffs and the universal or tariffs, there would be 5 or maybe many more than 5, several more than 5 justices who would be inclined to go that route. Getting there is hard. Not hard for the chief. The chief is fully capable of writing an opinion, actually, similar to the one that the Court of Appeals wrote in Yoshida back in 1975, which is kind of a little bit of this, little bit of that. You can go up to this, but no further. It's not the kind of formalist, textualist opinion that this court purports to be enamored of these days, but he's fully capable of drawing fine distinctions. Look at the immunity, the presidential immunity case, where he's just pulling all sorts of things out of the air in order to set, purported boundaries. I think if that opinion writes, an opinion that leaves presidents with some discrete power to deal with what everyone would agree, or Congress would agree, are exigencies that warrant the use of tariffs, but that don't give the president an uncheckable power to do the kind of things that Trump has been doing lately, that will be the outcome. I don't know whether that writes or not, though, and whether the chief and others can get a consensus when they meet on Friday, tomorrow morning, for that kind of an outcome. So it's possible that they'll simply say, hey, no, IEEPA does not authorize tariffs. There are other tools that do. There are other tariff statutes, and IEEPA gives them all sorts of other tools apart from tariffs that have been sufficient up until now, right? We've gone 50 plus years, and before that, many, many decades before that, with the discrete exception of the Nixon tariffs, in which presidents haven't had to do this. We've had plenty of foreign policy problems in which tariffs would have been a very valuable tool to induce or coerce nations to do what we want them to do. And presidents have been able to deal with those problems without reading IEEPA this broadly. So I actually think it's hard to call. I think it's likely they will not go with the government's broad theory, which would basically say the president can impose whatever tariffs he wants if he meets the statutory conditions under IEEPA and the Emergency Act here. But beyond that, I think anyone who's confident is kidding themselves about how this is going to come out. So I know that's not deeply satisfying, because I'm not giving you like Vegas odds on a vote count or anything like that, but it's just the truth.
It's a great answer. Let's stick with this donut hole argument that was made yesterday, that since it does, we all agree, IEEPA includes the power to ban importation. Why does it not include the lesser power to tax importation? I agree with the point you've both made that maybe the best argument is that revenue measures are just different. But what about this argument that IEEPA is an emergency statute, therefore authorizes emergency severe action like a ban, like a prohibition, like a prevention, the other verbs that we haven't talked as much about, but does not include more routine measures like raising revenue through the taxation of imports. Do you think that helps the plaintiffs, or is that just sort of a continuing weakness in their argument?
If that's addressed to me, I'm curious what Kathleen would say. No, I don't think it helps the plaintiffs. I don't think there's a theory. I don't think anyone's arguing that because you can only use this in emergencies, you can only do the greater and not the lesser. Why? Why would Congress not want to give you the flexibility to do lesser things that would be effective at dealing with the emergency? Why would you have to go to the, to the most extreme things when a lesser means would do? So I don't think that resonates. I think it was a nice, as Justice Kavanaugh said, it was kind of a clever oral argument line to come back and say that taxes are a different pastry than donuts. But then it was Justice Kagan that basically called him on that and said, why? I understand it's different. Why? Why would Congress not want to? Why would Congress want to give you these much more dramatic tools and not want to give you this one? And I think part of the answer is historical. Part of the answer is great doubts about the possibility of abuse by executives to raise revenue, to do this to raise revenue, I would say the Solicitor General, just interject this point, maybe Kathleen's covered it already. The Solicitor General was at such pains to say, this is not for revenue raising purposes. We're doing this, there's no abuse here. We're not doing this to fill our coffers. We're doing this, for foreign policy reasons. And then his client apparently came out right after the argument and said, we really need these tariffs because they're bringing in so much revenue to us. It's like, yeah, you have to deal with the clients that you got, I guess. But President Trump has not been shy about saying he's doing this, at least in part, for revenue raising purposes. Lawyers, the client determines things. I don't think the court thinks that there's no problem about taxing Americans for revenue raising here. They know that that's a problem in the case, and that's what gives them pause. But anyway, I think they see revenue taxes as different in kind, but they are struggling to be able to articulate, with the exception of Justice Gorsuch, who has a whole historical story about why taxes are different. They're struggling about how to articulate that and how that would cash out in terms of writing an opinion that isn't either all the way in the favor, either all or nothing. If I had to guess, they would like to fill the donut hole part way.
Wouldn't we all?
Terrible metaphors, but as long as we don't talk about cronuts, I'm okay with it.
A good Boston cream is better than a glazed any day. No, I'll just agree with Marty. I mean, apart from the great pastry debate, I think we're on the same page there. And it got even more awkward, right, when for some reason the SG went down the road of debating who is paying these, and it took him back right into the revenue aspect, which he then had to say was incidental and collateral. So I think there's a great deal of confusion around the revenue issue, and maybe it's for another day. But there are many ways for governments to raise revenue, and not just through tax. So it just that got pretty confusing pretty quickly. But I think more in the plaintiff's favor to say revenue is all about revenue.
Terrific. Let's focus for a minute on the discussion of the text of IEEPA itself. And so please talk about, what we fully expected the debate to be. Does the right to regulate include the right to tax? But then also bring in this discussion, I think, that was initiated by Justice Barrett about sort of the means to accomplish any of those 9 verbs, which relates to regulations through instruction, licenses, or otherwise. And what they were getting at there, the idea that somehow you actually could do this in a permissible way if you create an import license subject to a fee that would then be equivalent to a tariff. Marty, would you like to lead us off here?
So I'll lead you off a little bit, but but Kathleen knows much more about all these different tools and how they work. I will say this, it is interesting that Justice Barrett was like, no, I don't care as much about the verbs. It's the nouns. Let's go to the nouns. So either we're doing, you know, patisserie law here, or we're doing, I don't know, grammar law here. But what's interesting to me is that by the end of the argument, it was clear the SG had come in trying to think that he wins just by showing that Marshall, Madison, and Story all said that to regulate can mean we can use tax as a regulation. Of course, that's true, but the plaintiffs weren't contesting that. By the end, I think all the justices agreed that neither the word regulate nor even the fact that the word regulate is not usually used to encompass taxation or regulate in the company of all the other verbs in IEEPA is enough to decide the case, that those kinds of just strictly formalist considerations are not what's going to matter here. And to their credit, Catchall and Gutman did not suggest that they were, right? There's a flavor of it. Of course, yes, it is a strong rhetorical point that the word regulate, the verb regulate, is used throughout the US code, and it has almost never been understood to include taxation. That's a good point, but that's a point about the context of this statute within the corpus of all of Congress's handiwork throughout the US code. And that's the way to think about it, right? What seems to me to be the strong suit for the plaintiffs, and I think this resonated with most of the justices, was, of course, the word regulate can mean tariffs. It doesn't usually mean tariffs. But this is one area, unlike the other express and implied powers under IEEPA, in which Congress has otherwise engaged in a lot of very detailed, careful legislation, in which it has wanted to zealously protect its own power to decide when the executive should have this kind of broad discretion and when he shouldn't, and what the preconditions should be for imposing taxes, what the temporal and subject matter and country-based limits ought to be in various contexts. So when you look at Congress's handiwork as a whole, IEEPA, in the context of all these other statutes, that's what resonates. If the plaintiffs are to win, it's because we kind of understand that this is not the sort of thing that Congress would have wanted to delegate in this unbounded way. Given what Congress, whatever the reasons are, historical, practical, jurisdictional, whatever it might be, Congress thinks that taxing is different and has acted in a way that taxing is different. And if we're going to, to be trying to figure out what Congress's design is here, as the Chief Justice wrote in King versus Burwell, it seems to me that it's more looking outside of IEEPA, or where IEEPA is in relation to all these other things, that is going to determine where the court lands. But they're also going to think that I think that their questions reflected, they think a reasonable legislature would not have wanted to preclude the use of taxes as a tool in genuinely exigent circumstances that Congress had not foreseen in its other statutes. Now, one thing that Kathleen might know that I don't, and that's part of the briefing, I haven't really focused on it, is there are other tariff provisions that are tailored to the kind of national security emergency that are more tailored than IEEPA. And that's in the briefs. It didn't come through so much in the oral argument yesterday, but that it's not like Congress has been ignorant of this problem. They've dealt with that too, and that the president should be relegated to those tools in the kind of hypos, the hostage hypo, the war hypo, taxing India to try to get it to act differently with respect to Russia and Ukraine, those sorts of hypos. It might be that Congress has provided the president with sufficient tools, but within the metes and bounds that Congress has set out. But I apologize that I don't know those metes and bounds. I don't have them at my fingertips.
No, perfect segue to Kathleen. Kathleen, do those other tariff authorities address these kinds of exigent circumstances, including the hypos that the justices raised yesterday?
No, it's this is why it's always fun to chat with Marty and colleagues who see this from a different perspective, because Marty, you were saying that how unbounded this is, and as compared to the other ones that are more tailored. That's true. There's no question about that. That's true. And you add on top of that the fact that all those other ones appear in one part of the U.S. code, right? And IEEPA is out in Title 50 on its own. So there are distinctions, but what's interesting from a trade person's perspective, I think, is that as compared to other trade delegations, those look relatively unbounded to a large degree, right? If you compare some of these, we call them, the 3-digit tariffs, Section 232, 301, 338, 122, 201, and the list goes on. If you compare those to, for example, what Congress does with respect to tariff lowering authorities, like in Trade Promotion Authority, where we make FTAs, we go out and let the president negotiate things. In that circumstance, the Congress is very hands-on, right? Congress wants to have a lot of oversight and all that, and that has built up over the years. Whereas these other ones, these national security related tariff raising authorities that we could go on about at length, that hasn't been the case. And so it's all a matter of perspective, right, as to how bounded something is. But yes, I think we at least agree without difficulty that IEEPA is way out there, even compared to those other ones. So what are those other ones? That sort of, I think, begs the question as to whether he can recreate all of this stuff without this power. And part of what maybe some of the justices were getting at, and maybe frankly, which sort of changes in their mind the outcome here, right? If he can achieve the same, then you take away some of the political pressure that maybe the court faces. So yeah, I think he can do pretty much everything he's doing. I would go so far as to say a 100%. I'll come back and prove me wrong. I hope it doesn't come to that. But I do think that he could do all these things, and he could do them pretty quickly. I know there is process. Of course, there's process in these other statutes, but a lot of them have shortcuts. And it's not that much process. Again, it's a matter of what's relative to other statutes. So he's already.
Kathleen, can I interrupt as the outsider who doesn't know all the trade law and all these statutes the way you do? And when you start ticking off the numbers, it's like that old joke about the joke book in the prison. It's like your audience here, like when you say 338, it resonates with your audience, and I have no idea. But two things occurred to me. Is that right? Like even Switzerland, like. Part of that was coming up in oral argument. It's like countries that have never done anything bad to us at all, they're being subjected to this. It seems very blunderbuss. Is it really true that he could do this? But more importantly, his whole shtick here is that what's important is that he puts down these markers and he uses them for leverage for his famed negotiations. And so they're changing from week to week, right? Like he negotiates this exception with this country this day and this with the other. And do any of these other statutes allow this kind of dynamic, like constantly shifting tariffs country by country, week by week, which seems to be what he really wants to be able to do? And I think probably explains why he wanted to use IEEPA rather than these other tools. Can he do that kind of thing? This kind of every week it looks different. Like some countries have different rates on different products on a Thursday, and then next Tuesday it's all different.
So, and this we could spend another hour on this, to be sure, and I'd love to spend another hour on this at another time. But I think what let me back into that, Marty, if I may, because first, to be very direct about answering it, there was case law, there is case law, and there were challenges to his ability to modify some of the tariffs in the first term, which then continued into the Biden administration, and the courts who were facing those challenges basically gave the blessing that he can make these modifications. Now, where the administration was occasionally put in its place, it was with respect to some of the processes that were used, right? It has to, in many instances, follow the APA, for example. So we could get into that later, but I think to your point about modifications, we have some case law to suggest that yes, he can. But so one thing I would just add here, and again, I'm not maybe going to answer all those points just in the short time that we have, but he's already doing this with some of these other statutes, what I also call sort of more precision tariffs. That is not necessarily in anticipation that he's going to lose this case, but if I'm going to give some credit to the administration, it would be in this respect. That is to say that he's using, for example, 232, which I think our audience, but to remind everybody, right, is the national security tariffs. Where he allows him to put tariffs. This was a matter of debate, actually, a bit yesterday with respect to the Algonquin case, but allows him to put tariffs on products that threaten to impair the national security. And so what we've seen a lot of 232s in recent months, so that even if the IEEPA tariffs fall, these products will be covered. And they're big, big categories. And I don't like to give ideas, but could you imagine 232 that said all foreign products threaten to impair the national security? So we're now going to put tariffs on all foreign products, or you can imagine some crafting of language that doesn't land too far from there. But so he's right now, I think, using the 232s to fill in some gaps, right? And it goes to the point that some of these tariffs are used for different purposes. Right? You could have a 301 that covers a lot of countries. You could have a 232 that covers a lot of products. But what you also see, and this is just a footnote before I pass the floor back to Mike, what you also see in those contexts, which we haven't seen quite to that same degree. I know, Marty, you're saying there are a lot of adjustments here and there, but you're also seeing the advent and proliferation of exemptions, exceptions, relief for certain industries or even certain companies that we haven't quite seen in the IEEPA space. So IEEPA, right, we've got Annex 3 on one of the EOs that says, if you do a deal with us, these products might be exempt. But over on the 3-digit side, you're getting more precise exemptions, exclusions, and so on and so forth. So all of that and more. Let's just leave it there.
Terrific. We're running a little short of time. I want to do two things before we close. One, Marty, you explained we're not likely to be able to decide this within the four corners of IEEPA. You got to look at context, including Title 19, where all the tariff authorities are. There were also several other concepts discussed yesterday that could influence the outcome: major questions doctrine, non-delegation doctrine, foreign affairs powers. Maybe you could briefly talk about some of those. And then, Kathleen, there was a little bit about the consequences of a decision that goes against the government, consequences being refunds to private parties, as well as these tariffs being the basis for international agreements. We don't have a lot of time. This is going to be a challenge, but Marty, let's start with you. And then
I'll do the short version on foreign affairs. So there's at least two different versions of the way foreign affairs and national security are interjected into the argument yesterday and into the case. One of which very much resonates for the government and for the Solicitor General, and the other of which was a dud. The dud was the suggestion that this is an area, and I think he was putting this in here to try to get Justice Gorsuch's vote, and so that Justice Gorsuch wouldn't be concerned with the broad non-delegation concerns that he has, by saying, this is an area in which the president enjoys lots of Article 2 authority, and therefore the non-delegation rules ought to be looser. He's taking that right from Justice Gorsuch's dissent in the Gundy case, where Justice Gorsuch said that. But Gorsuch himself and all the other justices who spoke to it push back against that here. It's like, yeah, the president has lots of Article 2 authorities, but they don't include imposing taxes of this sort on American persons. So just get off that. You're not getting anywhere with Article 2, which was nice to kind of like show Justice Gorsuch that it's, his carve out for this is not as easy as he suggested in Gundy. More broadly, however, there's the idea that that IEEPA is about emergencies that deal with foreign affairs and national security and not merely domestic law. And that's an area in which it's fair to assume, as a general matter, that Congress would intend to delegate more broadly to the executive, as it has historically, than purely domestic questions. Just when you're getting to what would Congress have wanted, what is Congress trying to do? The problem, as the Chief Justice pointed out, is this is not a binary. It's not either a tax or a foreign affairs emergency statute. It's both, right? That's the point, is that it's a dessert topping and a floor wax. You guys are probably too young to get that reference. Right, it is both a tax. The whole point is that it's being done partly for national security and foreign affairs reasons, at least it ought to be, or it's supposed to be, and it has at least the effect and possibly the intent, at least in part, of trying to raise revenue from Americans. And so it's kind of a hybrid between the foreign affairs and the domestic taxing power. It is turned inward, as Justice Robert Jackson talked about in the Youngstown steel seizure case, and that's where we ought to be most cautious about assuming presidential authority from Congress. But there's this other, but they're worried about cutting off presidential authority that they think Congress would have wanted the president to have for actual national security, foreign affairs exigencies. And so this idea, is it a tax or is it national security? The answer is it's both, and that's what makes it a hard case.
Thank
So
you.
continuing, Mike, into the lightning round here, you asked about deals and refunds, particularly. So let's start with the deals. I think it's complicated, but they're likely not affected. And that's in part because my position is that to the extent we have deals, they were probably not authorized in the first place under U.S. law, but I'll come back to that in a moment. So first of all, first point is that I think our trading partners may prefer the deals that they have now to what he might do in the future. And we were just talking about the other statutes that could be used. We could expect the president might invoke more of those, right, and might issue more proclamations even before the decision comes out. So keep the deal, keep the status quo, onward. Second, it might depend how the court writes the decision. So if the decision only deals with the tariff as the tool and the emergencies still stand, which I think we can expect because we're not getting into those emergencies, there's still a basis, I think, for the White House to rely on those emergencies to say that the deals are unaffected, just in terms of the sort of concept of the deal coming from the emergency and addressing the emergency. Third, maybe last point is that even if not, what really are these deals? They are, what it comes down to in U.S. law, they are executive orders where the president has modified prior orders. And so, okay, you say these earlier tariff orders are dead. Well, look more closely at the content of the deal. Some of them are premised on IEEPA tariffs, but some of them are not, right? There's some dealing with 232, some dealing with 301. Some dealing with still other topics. So it wouldn't take much for him to write a new EO in which he claims reliance on the deal. Right, that's a big issue that Congress has never resolved, deals begetting more deals. So he could claim that he entered into the old deal under IEEPA, and now that requires him to maintain it. So it's long story short, I think the ambiguity behind what these deals really are and the way Congress has failed to police the president's claimed authority, trade agreement authority, are really what's driving that conclusion for me, that they'll say the deals are unaffected. Now, to the refunds, again, very briefly, refunds, really hard topic, and Justice Barrett, right, kind of tried to get to that, right? She always seems to care a lot about sort of the practical conclusions. And I think her words were, it's a mess, right? Everyone said it's a mess. I think it's more of a nightmare, right? Just, and those who are listeners who are into customs, right, you know this, that entry papers, right, that you list the HTS code, but you don't disaggregate that, right, to say this, there are multiple tariffs that are applied here. So what's the sliver of your tariff bill, that is the IEEPA tariff? Very hard to say, right? Very technical, challenging work ahead for the customs teams. Not to mention that we still have that, what's called the CASA issue on the scope of who might be eligible for a refund here. Now, whether, we don't have time, but, whether that's going to come up in the court's decision, I think they may think about that, right? Will it just be the plaintiffs who have filed, or will it be broader than that? There was a class action filed a couple days ago, people may know, in the DC District Court that actually is going to the same judge, has been assigned to the same judge as Learning Resources. Very interesting. If that class action, right, that's trying to pull together a number of outstanding importers. I think the way it's framed is even bigger. Anyone who's paid a tariff under the IEEPA tariffs, right, they want to protect their rights, preserve their rights, and to be able to get refunds in due course. And lastly, I would say, the plaintiff's lawyer, Neil Patchell, suggested that there are still other options where he said that they could issue a stay, the court could issue a stay so that Congress could intervene to deal with refunds, or maybe more controversial, controversially, the court could decide to give only prospective relief. And there's a case that dealt with that in a recent term. That is, again, a story for another day. So not a lot of briefing on this, but we know that there are lots of investors out there that are bet on and purchase rights to refunds, which may be contrary to law. That's another lurking question for another day. So I think we should expect to see more of these lawsuits to follow, whether there's an administrative agency solution, a litigation court-based solution, or a congressional legislation solution, or some combination of all three is anyone's guess.
Terrific. That's great. We have reached our time, so we'll close it here. Thanks to everyone for joining another Fridays at the Exchange, and we'll look forward to seeing you next week. Thanks you both very much.
Thank you for watching and listening to WITA's Friday Exchange. WITA is the International Trade Membership Association. If you haven't already, be sure to subscribe on Apple Podcasts, Spotify, or YouTube. New episodes drop every Friday, and you'll be the first to know. Thank you for joining us, and we'll be back next week with WITA's Friday Exchange.